In 2025, with the EB1A approval rate going down across the board, does it still make sense for you to try this type of case, or would you be better off waiting or trying something different? This is such a deeply personal decision, and there is not going to be a stranger on the internet who's going to give you the right answer, but I can give you some things to think about. Um, First of all, the reason the approval rate is going down is based on many factors, and we don't have all the answers. I suspect it's two main things. USCIS is moving the goalpost. They're becoming stricter. There's this increased talk of like, oh, is there fraud? Are people abusing it? It's happened so many times over the years that it happened with national interest waiver. The case type gets really hot. Lots of people are using it successfully. Maybe the quality of some of the filings goes down a little bit because more people are jumping in as they hear that it might work for them. And USCIS clamps down and gets stricter. The RFE rate goes up. The denial rate goes up. The other factor so it could be USCIS changing the goalposts. It could be the quality of some of the petition filings going down. I feel like in such a short time that the Trump administration has been back, the change more so has to do with USCIS changing how it's adjudicating than it does with a big change in the applicant pool. I would say there are a lot of people filing for EB1A, not because they're really at the pinnacle of their career, but that because it's their best option and they don't have a lot to lose by trying. So maybe they would be better applicants in 10 years. But right now, this is something that they can do that has a reasonably decent chance of working. So people are putting forth petitions that may not be super strong. Sometimes when others see a case win of a colleague, they're like, that guy wasn't that great. His career wasn't even that great. It wasn't even as good as my career. Guess what? That doesn't mean it's fraud, and you shouldn't go reporting him for fraud unless you have a reason to know that there was specifically fraud. USCIS doesn't adjudicate with some ironclad rubric where, they determine with complete consistency and no arbitrariness who wins and who loses. Your case is going to be adjudicated by a real person coming to it with whatever information, whatever educational background, biases, and whatever, how they're feeling about their day, that all could shape how they feel when they look at your petition and if they find it compelling and convincing and worthy of approval or they don't. So it's totally possible that people with very similar criteria could have different results, or somebody who you think is lesser, in some objective way could win while you lose. This is so frustrating, and there is so much ambiguity in the process. Just because someone else wins doesn't mean they cheated. And just because you lose doesn't mean that you can't win on a second try, or that you don't have value, or that it was a mistake to try. Because it's just not like a simple points thing. It's not like, oh, check the boxes. I checked enough boxes. You have to make me win. The final merits determination makes the whole EB1A so much trickier because you just can't know how this holistic aspect of the review is going to play with the adjudicator that you get. And this year, I've seen so many more things move that way with immigration benefits adjudication that it's so much more about, there could be even other outside things incorporated into the decision, and you can't even know what all those things are. We're seeing it with visas, with this more extensive social media review. We're seeing it with naturalization, with the good moral character standard kind of being broadened. That's the total trend, is that the adjudicators are not going to be limited to what's on the piece of paper. Now, they're not going to go beyond, and you certainly shouldn't expect them to do extra work and go educate themselves about your profession. They're not going to. But they can use outside factors to have in mind or to look up and use against you in your petition filing. And I worry a lot that, because so many EB1A petition filers are long-term H1B workers who are vastly disproportionately Indian, because Indians wait the longest to get a green card, that it can make adjudicators feel kind of jaded to say, oh, here's another Indian H1B guy coming across my desk. And I worry that they will look at this high volume of filings from people with these superficial similarities and just kind of get sick of it and make the bar higher. There have been times in the past, for example, L1A visa adjudication, where Indians getting their visas adjudicated in India were just facing a lot higher standard than people anywhere else, and consular officers were using kind of a shorthand way to see whether someone's managerial experience was adequate to earn an L1A. It was just higher than it was anywhere else in the world. I really would hate to see that play out in the data for EB1A adjudications. But it's not outside the realm of possibility that it would.